Thank you, Maria. Welcome to Pinellas County's webinar about the new Tenants Bill of Rights ordinance. I am Carol Strickland, Housing and Community Development Director for Pinellas County. In August, the Board of County Commissioners passed Ordinance 2227, which adds new provisions for tenants and landlords. The ordinance requires landlords to provide tenants with a notice of rights. Document prohibits discrimination in leases based upon a tenant's source of lawful income, and also requires notice of late fees and rent increases of more than 5%. Today, you'll be hearing from staff from the Housing and Community Development Department, the Code Enforcement Division, and from Consumer Protection Division, who will join us by pre-recorded video. They will give more details about each of the ordinance's requirements, how compliance can be achieved, and how it will be enforced. The purpose of this ordinance passed by the Board of County Commissioners is this: reduce evictions and homelessness by providing protection to residential tenants in Pinellas County, including notification of renters' rights, late fees and rent increases, and protection from income discrimination. We want to make sure and emphasize that we really appreciate our landlords who work hard to make sure that tenants have safe, quality housing. We will continue to work with you to make it easy to comply with this new ordinance. We especially want to acknowledge our partners like the Bay Area Apartment Association. We're committed to keeping open communication with your members and professionals in the community to make sure everyone is on the same page about this ordinance. I wanted to note that although we're not going to be taking live questions during today's web presentation, we will invite you to email any questions you may have after the webinar to homesforpinellas@pinellascounty.org. Our staff will work to answer any of your questions individually, while also posting answers to more common questions on our website. I also want to mention that there's detailed information about the Tenants Bill of Rights, including the full ordinance, the notice of rights document that landlords are required to provide, all on our website, which is rent.pinellas.gov/tenants-rights. And thanks again for joining us today. I'll now turn it over to our first speaker, Evan Johnson, the Planning Division Manager, to give an overview of the ordinance requirements.
Thank you, Carol. As Carol mentioned, I'm going to provide you all with an overview of the ordinance, starting with the applicability. So this is a county-wide ordinance, which means that it includes both the unincorporated area as well as those areas incorporated within cities. There are two exceptions to the countywide requirement or application. First would be if a city has already adopted a similar ordinance, that city ordinance will prevail. A city may also choose to opt out of the county's ordinance at any time. As of this webinar, no cities have chosen to opt out of the ordinance, and the effective date is October 3rd of 2022. There are a couple of main parts to the new ordinance that I will be covering in more detail through the rest of this presentation. First, there's a new series of notices that landlords are required to provide. First is the notice of rights under federal, state, and local law. Second is a notice of late fees. And third is a notice of rent increases. The ordinance also expands county code to include a provision prohibiting discrimination based on source of income. So the first notice is the notice of rights. And upon renting, signing, or renewing a lease, a landlord is required to provide a tenant with a written notice of rights. This notice has been created and it will be provided by the county, and it's available at rent.pinellas.gov. It's available in both English and Spanish. The notice must be provided in hard form, in paper form, unless the tenant has consented to receiving notices electronically, and then it can be provided in that way. In order to show compliance with this requirement, a landlord can request or should request a written, dated, and signed affirmation from the tenant stating they've received the notice of rights. That affirmation then is retained by the landlord for at least 1 year after the tenant vacates the rental unit. The next notice is the notice of late fees. Landlords are required to provide a tenant with a written notice of late fees to let the tenant know a fee has been incurred. This notice will include the reason for the late fee, the amount of the late fee which is due at the time of the notice, and finally, if the late fees will continue to accrue, the notice must include information explaining the rate of accrual. And the final notice requirement is the notice of rent increase. And this requirement applies to any rent increases of more than 5%. There are 3 tiers of notices within the ordinance. The first is a 60-day notice for leases that are 1 year or longer. The second is a 30-day notice for leases that are between 3 months but less than 1 year. And the third is a 15-day notice, which is required for any lease that is on a month-to-month term. These notices for the notice of late fees and the notice of rent increases can be delivered in a number of ways, including in an email, if the tenant has consented to receiving notices in that manner, on paper via certified mail, on paper posted securely to the door of the unit, and then finally on paper and hand delivered to the tenant. The final provision that I'll be discussing today is the source of income discrimination. This ordinance prohibits discrimination based on a lawful source of income, which can include employment wages, public or private assistance programs, and a variety of other sources as detailed in the ordinance. Now, this requirement does not require a landlord to reduce the amount of rent normally charged for a rental unit, or waive any security deposit, fees, or similar charges that are required from all tenants renting from that landlord. Any inspections that are required by public assistance programs must be completed within 10 business days by the appropriate agency. This requirement, again, does not require a landlord to alter a rental unit to meet any requirements specific to a lawful source of income if not otherwise required by laws applicable to that unit. Now I'm going to turn it over to Jude Reason, our Code Enforcement Division Manager, who's going to talk a little bit about how this ordinance will be enforced.
Thank you, Evan. Good afternoon. My name is Jude Reason, and I am the Code Enforcement Division Manager and Pinellas County Housing Official. Pinellas County Code Enforcement and the county's Consumer Protection Office are authorized and have been designated to enforce this ordinance. Code enforcement will investigate allegations of violations of the ordinance sections pertaining to the notice of rights, late fees, and rent increases. Whereas the Consumer Protection Office will investigate allegations of income discrimination. The associated penalties for violating the ordinance may encompass a fine of $500 for a first offense and any subsequent offenses. At Code Enforcement, our mission is to promote the health, safety, and welfare of the citizens of Pinellas County. We do this by enforcing codes and ordinances subject to our jurisdiction through good communication, partnerships, education, outreach, and other legal remedies. When appropriate, our officers and staff strive to resolve violations through voluntary compliance efforts before taking punitive enforcement actions. In most cases, Pinellas County Code Enforcement limits our jurisdiction to the unincorporated areas of the county. However, in some situations, and for the purpose of this ordinance, Code Enforcement is responsible for the enforcement efforts in all participating jurisdictions and municipalities. Citizens are encouraged to notify Code Enforcement of suspected violations of county ordinance, and we have multiple paths to report these complaints, either by calling the Pinellas County Code Enforcement complaint line or through the Pinellas County Citizen Access Portal. And citizens are always welcome to hand deliver complaints directly to our office. Once complaints are received, they are then assigned to the appropriate investigations team, who will respond and investigate in accordance with Pinellas County ordinance and pursuant to law. In addition to Code Enforcement, our partners at the County Consumer Protections Office are also available to assist citizens. Our Consumer Protection Office Chief Investigator, Mr. Doug Templeton, was unable to make an in-person appearance today. However, he has recorded a short video that will provide some additional context in regard to Consumer Protection's role in the enforcement process.
Good afternoon. My name is Doug Templeton. I'm the Chief Investigator with Pinellas County Consumer Protection. Today, I'll be briefly discussing Consumer Protection's role as it pertains to the investigation and enforcement of the Tenant Bill of Rights, specifically the prohibition of discrimination involving a tenant's source of income. Consumer Protection assists in maintaining a strong quality of life for our residents by reducing victimization and promoting economic stability. We accomplish this through partnerships, proactive regulation, investigation, and education to protect residents from unfair, deceptive, or fraudulent practices. Consumer Protection is responsible for enforcing Section 42-435 of Tenant Bill of Rights, discrimination relating to public assistance. The Board of County Commissioners desires to eliminate discrimination in a person's ability to obtain housing based on a person's lawful source of income for rental payments, thereby increasing the number of households who are able to successfully locate safe, affordable, and accessible housing in Pinellas County. As with the rest of the ordinance, it applies countywide, except where cities have adopted an ordinance. The Tenant Bill of Rights is effective October 3rd of this year. Complaints can be filed in writing through mail, email, or online through the Citizens Access Portal. When a complaint is received, it'll be assigned to an investigator for follow-up investigation. They'll reach out to the parties to obtain additional details and any supporting documentation that may be available. When appropriate, a warning or citation can be issued. However, we want to provide opportunities for compliance through education and outreach and allow landlords and tenants to be successful in their relationships. Consumer Protection staff will respond, investigate, and enforce accordingly pursuant to the ordinance and law. Thank you, and we'll hand it back to Carol now.
This concludes today's presentation, but before we end today's session, I want to remind everyone that our staff is here to continue working with you to make sure you understand all of the requirements of the new ordinance and all of your questions are answered. You can send in any questions you may have to homesforpinellas@pinellascounty.org. Our staff will work to answer any of your questions individually, while also posting more common questions on our website. As a reminder, you can also find information and key resources like the required notice of rights on our website, rent.pinellas.gov. This webinar will also be posted on that website later this week. Thanks again for joining us. Have a great rest of your day.